Back. It's the newest episode of Counsel and Commentary, and today I have a special guest and the first of this industry, Emmanuel Coffy. Welcome to the show.
Thank you. How are you today?
I'm doing well. And what I meant by first, this industry, he does patent. We haven't had a patent attorney on, so this will be a fun, interesting, and delightful conversation. He's also got 2 books coming out. And first, we'll start. What kind of drew you into specializing to patent law?
All right. Let me just say that I started out as an engineer, worked in different industries for different corporations, electrical engineers to be sure, for about 19 years. And then as I was getting older, people were sourcing out to China and other places like that. So I needed to find another profession where my gray hair would add some value to it. And so hence I went into patent law.
I love it. Can you give me a simple definition of what patent is and why it matters? Because, this kind of, most people don't know exactly what it pertains to.
Okay. Well, patent is a limited monopoly. It's a limited monopoly which gives the holder the right to stop others from doing the product that is patented. The system, well, this commerce being that we know monopoly is not good for progress. When someone has a monopoly, they have no reason to make any effort to do anything else, right? And so that's what patent does. It provides you with a limited monopoly for about 20 years now. You can stop others. It does. See, this is another thing about patent. It's referred to as a negative right because it provides you the right to stop others from selling. That's what it does. It doesn't provide you directly the right.
To give some clarity on that, what are the typical clients you usually work with? Is it more startups, investors, corporations? Who do you typically serve?
Yeah, typically startups and small business enterprises.
And I know we were talking with Sal from Top Attorneys of North America. This podcast by partner with. What is the 2 books you have that are coming out or are out?
Thanks for asking. Yeah, one of them is The Value of Your Ideas, which people can get from Amazon. And it really provides some details, patent law being somewhat exotic. Not too many people are familiar with it. So at least we write it in simple language so people can understand. So you can get a copy at Amazon. The other book is the App Developer's Guide, because we know nowadays we have a lot of software people out there making apps, and so provide them some guidance as to how they can protect their work.
Perfect. Yeah, that's pretty useful, especially with a lot of people building SaaS softwares nowadays. Well, let's get more understanding patents. What are the main type of patents? Utility design, etc. How do they differ?
Okay, so we have utility, we have design patent, we have plant patent. So how do they differ? Utility is just like it says, you patent the utility of a product, whatever it may be. It doesn't have to be. People have the idea that it has to be somewhat of an exotic idea. It doesn't have to be. Look at 3M, for example. They made Post-it notes, right? Very simple, but yet it's patented because they don't want you to be able to make the same product as they do. So that it has a certain utility to it. Okay, the design patent protects the ornamental value of a product, the ornamental value of it. So what it looks like, how it looks like, its shape. For example, if you take the Coke bottle that has the shape, a certain specific shape, then they protect it under design patent. Now, you take it has a design patent, but it could also have a process. But in the case of Coke, it has a trade secret because up to now, Coke has always been kept as a secret. So no one
Yeah,
has been able to reverse engineer it yet.
that's kind of like with some franchises have that too. Some of the restaurant recipes very similar to that. How do you determine whether something is patentable?
All right. The test is you do a search, do a quick search to find out if there is anything out there like it, or if there is what's referred to as prior art, meaning that if it's been described somewhere in the world prior to you coming with your idea. Uh, they can use anything out there. By day, I mean when we talk about the process, the examination process, the patent examiner can use anything that is written out there in order to reject your application, to show that there is someone else, or there is an application that claims the same utility, in case of a utility patent, the same utility that you are claiming. And so therefore we reject it. So if you are in the industry, let's say if you are an inventor and you are in the industry, you should know what's available and what's not available. Most likely, how do people come up with those ideas? It's because they have a need and they go out there, they search for, they cannot find anything that serves that need. And so, like they say, misery is the mother of all inventions.
What's the difference between a patent, a trademark, and a copyright?
All right. A patent, again, is a limited monopoly for 20 years. A trademark is uh, uh, not is a trademark defines the source of a product. Take the golden arch, McDonald. It defines the source of, we know what McDonald stands for. If you take, for example, the Mercedes logo, right? It defines the source of the car. So that's a trademark. Copyright, anything that is written on a piece of paper or tangible medium is copyrighted. Now, uh, anything. If you remember when you went to school and you were doing your homework or whatever, all of that is copyrighted. Except now, what happens is you should register the copyright with the congressional house so that you give notice to the world that this is my copyright. That's the only difference. But otherwise, I guess quite a while, there was some time ago when they used to say the Chipman, Pullman copyright, where you write something and you mail it to yourself in order to show that, that it's copyrighted. But nowadays, there is a process that the government, you send it to the government and they provide you with a registration number.
Perfect. Some good insights there. Because this is a industry a lot of people don't know much about, but they need to know about. What are the biggest myths or misconception inventors have about patents?
Misconceptions about patents. The misconception is that you have a patent and you think your patent gives you the right to provide you with more rights than you actually have. A patent, when we talk about a patent, let's consider a house. It has boundaries, right? The same thing for a patent. It has boundaries the, that limit your rights, and those boundaries are found in the claims of the patent.
So as we talk more about the patent process, what's the typical timeline for getting a patent approved?
Okay. Well, it all depends. The patents office is divided into technology centers. You have, for example, you may very well have a mechanical center, an electrical, even in the computer science center, you have different centers for different technologies. And so each would have a different workload, which determine how long a patent is done. In one technology center, a patent may take 1 year. In another one, it takes 3 years.
And for context for somebody's listening, how expensive is it realistically to pursue a patent from start to finish?
Well, again, it all depends. If it is a very simple mechanical patent, it's not that expensive. But when you move to like complex mechanical, it costs in the tens of thousands. Pharmaceutical, just forget about that. It's very expensive from start to finish. And again, it all depends on what we define as start to finish. Because let's say the examiner rejects your patent and for the first time, you respond to their objections, and they're not satisfied. They reject it a second time, and then you disagree. You said, "Well, no, I disagree with you, Mr. Examiner or Madam Examiner," and so you take it to the patent appeal. And at the patent appeal, it takes a long time. So if you draft your patent such that it's very narrow, then the chances of getting your patent quicker, but then you give up some land for that matter. So it's a trade-off. So you draft your patent narrow so that it has a better chance of getting to issuance.
That's some good clarity there. What role does a patent attorney play versus a patent agent?
All right. The difference is uh, an agent, well, I guess an agent has, all right, let's back off. To become a patent attorney, you have to have, first of all, you are an attorney, you admitted in one of the states, and you also now have to take the patent bar. This is an additional uh, license that you have to have that makes you a patent attorney. The patent agent takes the same patent bar that you do. So in that sense, the patent agent can work with the patents office just like you can. Again, the difference being that you are an attorney and they're not. And so if they cannot litigate or they cannot represent a person outside of the patents office.
I was just curious about that. How often do patents get rejected and why?
All right. A patent is rejected, as we were saying before, because it is described, it is found in the public domain somewhere out there. It is found. The examiner can take, if we have different type of rejections. There is a first rejection where your patent, your application is found out there verbatim, right? There is something else out there which really looks like, walks like, talks like your patent. And so therefore, that's one or two as it referred to rejection. The other type of rejection is where the examiner has to take two prior art, two documents and merge them and say, well, uh, someone who's versed in that space can take those two and merge them and 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 that would also read on your application. So an artisan of ordinary skill, that's the wording. Artisan of ordinary skill in the art can use those two documents, merge them together, and it's the same as your patent. That's the second type of application on the substance. The other rejections are more like form, because there are certain forms that the application should be in and other things like that, but they're not as substantive as there is another rejection nowadays, more and more. It's when, because after there was a case in Supreme Court where they say, especially in the software world, you cannot patent software. In other words, because you cannot just come and get a patent for software. And so that's another rejection nowadays, referred to as 101 rejection. For those who know what that means your software is not accepted, it's rejected.
The clarity. Let's kind of segue over to business and strategy. What should a startup consider patents early, and why are the risks if they don't?
Yeah, well, very good question. Now, again, as we indicated that a patent provides you with a monopoly. And so as you spend money, time, and effort to up come to the market with a product, you would not want someone else to have had uh, this monopoly. And here you are at a very later stage, you find out that oop, the product that I thought I could use or I have, I no longer can do so because someone else has a patent. So before you do anything else, you should invest in a patent. Not only that, the other reason is because the patent itself and by itself, even if you do not proceed to manufacture the product that you've invented, you can sell the patent or you can license the patent.
Yeah,
So
that's a
that is a reason why startups should really at the very early stage uh, look to see if their idea is patentable.
That's a perfect segue to the next question because you identified as another asset that's you could license out or sell it as a separate entity. How else do patents add value to business, especially when raising capital or seeking acquisition?
Uh, well, again, the main way is because you have a monopoly that allows you to keep others from that space. Now, here is another thing that you can do in that area is one patent sometimes in itself is not uh, is not sufficient. It all depends on the area on the segment. Let me give you an idea. We went at some point. There was you may not be old enough to remember tubes, right? All the radios, amplifiers, everything else used tubes, right? And we went from tubes to to a transistor. And so that's, in other words, it's very innovative. There is no one else out there in that space. You can afford to just say, well, okay, one patent is sufficient for me. But in a crowded space, you may have to obtain other patents, right? To kind of, again, when we go back to the house, the perimeter, to make sure that you cover all your perimeters. So that's, again, a reason why you may have to have what we refer to as a patent strategy. So you sit down, you analyze your market space, and you determine if you need to have what's referred to as a family of patents that cover the whole aspect of your product.
So it gives like a protection, like layers of protection. How do you
Right.
protect intellectual property when working with manufacturers overseas? I know a lot of people do e-commerce nowadays. So what are some practical ways to protect?
Well, practical ways you have, for example, you have the PCT, which is for European countries. So you can, after you apply in the United States, you can then request that the uh, the the PCT provide you the same protection because a patent is really local in terms of the U.S. Provides you with a patent that doesn't protect you in Canada, that doesn't protect you in Europe, it doesn't protect you in Brazil or Africa or China. You have to go to each of these uh, places and obtain protection based on your U.S. patent.
And this would be a perfect segue then. So what are some strategies for building a patent portfolio instead of just filing a single patent?
Again, is based on the market space that you are in will determine what it is that you do, to build up a portfolio of patents. And again, if you go in China nowadays being uh, a quarter of the world's population. So you may want to target China, and so that will then you will have to specifically go after what the Chinese market wants, and then obtain a family of patents for that purpose.
And how does patent law differ between the US and other countries, for example?
Well, the difference, I think maybe the difference may be a lot more between the US and China, but between the US and the European, it's just in how you present the application itself is really the difference. But otherwise, everybody agrees that about if you have an idea and no one else has it, then it should be patented. So it's pretty much universal. There is one point, though, we should add by saying universal. At some point, the difference was that the entire world was the entire world used a different system than the United States did. Uh, the United States had a system where that it said the first to invent is the first to get the patent. But in 2013, it changed because the whole world was on a system where the first to file gets the patent. Whoever files first gets it. Whereas the world was on, I mean, the US was on whoever invents first. But in 2013, about 12 years ago, the US switched over to whoever files first gets the patent, which makes a very, very big difference, especially with startup, which we didn't mention. You don't want to wait because if you wait, someone else may get to the patent office before you, and sorry.
That's why we got to hire an attorney like you.
Thank you.
That's a selling point alone right there. With rapid innovation in AI, biotech, and software, how is patent law evolving?
All right. Right now, as far as AI is concerned, uh, AI cannot be an inventor. And you can use AI to invent, but it has to have some human intervention. So AI is just a tool, just like any other tool that you use right now. So and we'll see and see if that changes.
I think the rise of patent trolls, companies that buy patents just to sue others, what do you think that does to the marketplace?
Yeah, it really because they just purchase a patent troll only purchases the patent only to litigate. They don't have any interest in manufacturing the product, in delivering it, in servicing it, or anything like that. So, having said that, you can see that they're not they do not provide a new device to society, and so all they really do is making money out of the patent.
Yeah. What technology is changing the way patents are searched, filed, enforced? I know you kind of touched on a little bit, but what technology is changing and like how the whole process basically?
Well, with AI is changing how things are done in a simple way, very short and sweet. AI changes, everything is changed.
Yeah. Yeah. What would be the first step as an investor or startup founder should take before contacting a patent attorney?
Well, I would say contact the patent attorney first. Well, no, they should just have a clear idea as to, and they have the term sheet, they have all sorts of other things that they have out there. They have a clear idea as to their goal and objective, and they have a business plan and all of that. Then they contact the patent attorney.
Perfect. What are the biggest mistakes entrepreneurs make in the patent process?
Biggest mistake is to wait too long. By that I mean, especially in the examination process, because remember we said that if you do not agree with the examiner, you can always appeal the examiner's decision. But that takes a long time, and the patent has a limited life. And even though once the patent is issued, then technology is advances. Now it used to be what 1.5 years, there is a change. Technology changes. I don't know with AI how long it is now. As you can see, your patent is quickly outdated during the examination process. And so you may want to be a lot more pragmatic than that and just say, give up some territory, like you were saying before. Let's draft our patent very narrowly so that we can get out of the system and we can benefit from what the patent allows us rather than staying too long in the examination process.
Yeah, that's a good point. I think it's kind of fascinating to see how like AI has expedited the process. I bet it's a few months compared to a year and a half. Even
Okay.
faster than that. Even like I saw something online that was saying that the college curriculum is over outdated by the time the books are printed.
Okay.
In the current environment we live in, by the time so the books they're buying and are trying to resell, they're just selling old information. So because everything's evolving so fast, and it's just crazy times we're in. Can you share an
Yes.
example of a client success story where patents made a huge difference?
Yes. Yeah, without I had a client who, and in fact, it was a design patent for that matter. And he said he came to us and he provided us with his business plan and his objective. And we recommended that he should, at the time, you could ask the patents office for acceleration to accelerate the examination process. And obviously you pay a fee for that and you get your. So he obtained his patent, his design patent, under about just about under a year. And so right there, I think he knew at the time there was one of those big names that was infringing on his patent. And so with the patent at hand, he went and litigate his patent. It was that was a huge difference. That made a huge difference in his business. He didn't for the amount of money that he spent in getting the patent as soon as possible versus the benefit he's getting from stopping those big names out there from making his product. I think that made a very big difference.
Yeah, it's priceless. You either had a business or nothing because the big money.
Yes.
So, and what's the typical length? Is like I know it varies based on how many inquiries are coming in. Is it typically like a year and a half? So it's expedited by like 6 months. Is that kind of give or take?
Give or take. Nowadays, again, like we are saying, since there's been so much change with AI, and I haven't done an accelerated examination lately, so the one the one I did, like I said, was about under a year, close to about a year. So it may change now, but I don't know by how much.
Perfect. What's the most rewarding part of your work as a patent attorney? Probably stories like that.
Yeah, and the most rewarding part is really when someone presents an idea and now you kind of counsel them to do it this other way, and you provide them with ideas on how to make their invention a lot better. And but you can never be an inventor. And at times, so a person would come to you with an idea that was like far away from what it should be, and you sit them down and you say, well, if I were you, this is how I would do it. But now here you playing the role of an inventor because you are based on the idea that they first started out with, then the end product really changed tremendously because you've provided them with counsel and guidance as to how to complete the invention.
Yeah, this would be a perfect segue then. So if somebody's listening, because you work with a lot of different inventors and startup founders, has an idea but doesn't know where to start, what advice would you give them?
Has an idea, doesn't know where to start, I would say just do a Google search, a very quick Google search, and see if there is anything remote to your idea out there. So that gives you a head start to know what to do next.
So basically, yeah, do a little,
Again,
I'm sorry.
no, again, it doesn't have to be rocket science. Okay, it can be very, 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 very simple.
Love it. Yeah, I mean, we have a lot of tools and resources to get incredible data ahead of time, so we know what we have. And especially as we wrapping this up, patents are like literally one of the most important things in people's businesses, and a lot of people, it's something that a lot of people overlook. How many businesses do you see that you think are overlooked? Like when you running through some of these businesses, do you have like a number, is there like an industry number that don't have it, or do you know offhand? I know it's kind of a random question, but I was just
Yes,
for
yes.
curiosity.
Now, I don't know offhand, but what I know is there is a reason why IBM has so many patents. There is a reason why Samsung has so many patents. And there is another reason why Apple has so many patents. And even, for example, if you take Uber, there is a reason why they have so many patents. Uh, and so that's why startups, especially startups, should really start with seeing or determine whether their idea can be patented or not.
Yeah, that's a great way to wrap it up. How can people get in touch with you or learn more about protecting their IP or
They
getting a patent?
can yeah, they can look me up. It's coffylaw.com, COFFYLAW.com. I'm on LinkedIn. They can find me there as well. So it's very easy. Or if you can Google my name, you should be able to find me.
Perfect. Well, thank you for your insights and your time, Manuel.
Thank you very much.
Yep. Thanks for giving some great insights on that Counsel and Commentary podcast about patent law. Thank you.
Thank you for listening to Counsel and Commentary. This episode has been brought to you by the top attorneys of North America.